Module 4, Record Keeping, Reporting and Training. In Section 24 of the OHSS Act, Reporting Incidents and Accidents, an accident means an accident arising out of and in the course of an employee's employment and resulting in a personal injury, illness, or the death of the employee. A hazard means a source of exposure to danger. Healthy means free from illness or injury attributable to occupational causes. HIRA means hazard identification and risk assess. Incident means an incident as contemplated in Section 24.1, including other less serious minor incidents and therefore used as a generic term as well. Risk means the probability that injury or damage will occur. Safe means free from any hazard. When incidents or accidents happen, there are a few things that must be done. Two of these things is recording or recording and reporting. When recording, any incident, regardless of its severity, including a near miss, should be recorded and kept as records for incident and accident management. This is a great tool to identify where risks are creeping through our safety management system. When it comes to recording and reporting, Section 24 incidents and accidents, as they are called, are incidents and accidents that fit the criteria in this section of the Act. The Department of Labor requires companies to record these on an Annexure 1 form and report them using the correct reporting forms. These may vary depending on who you have registered with for COID or compensation for occupational injuries and disease. The investigation should officially start within a period of 7 days and be finalized as soon as it is reasonably practicable or within the contracted period in the case of contracted workers. An employer must ensure that the incident or record be examined by the Health and Safety Committee. This is based on legislation given to us in General Administrative Regulations, Section 9 of the Occupational Health and Safety Act. An Annexure 1, recording and investigation of incidents document, must be kept for a period of 3 years. The investigation should be performed by one of the following persons: the employer or user of machinery, a person appointed by the employer to investigate the incident, the health and safety representative of the work area, a member of the Health and Safety Committee. Section 24 states that certain incidents and accidents must be reported to the Department of Labor. These are incidents or accidents that arose from their work or even in connection with their work. So even if the person was not working with a power tool, but someone in the vicinity was, and the employee was injured by that power tool, it's still considered in connection with their work and thus needs to be reported. You must follow the correct reporting procedure for incidents and accidents to the Department of Labor using the correct forms and in the correct time frame. For more information on this, please join our Incident and Accident Management course. Who must report these incidents or accidents to the Department of Labor? They must be reported to an inspector by the employer or the user of the plant or machinery. So, if you are an employee and were the user of the plant or machinery, you also have an obligation to ensure that the incident or accident was reported. When must these be reported? The above-mentioned incidents under Section 24A, B, and C occurrences should be reported immediately to the Provincial Director. It should be done by telephone, fax, or similar means of communication. They should also be reported to the Provincial Director within 7 days using the correct forms. If the injured person dies after notice, the employer or user shall notify the Provincial Director of the death by fax or similar means of communication. This is based on legislation in General Administrative Regulation 8 of the Occupational Health and Safety Act. The definition of training is the action of teaching a person a particular skill or type of behavior. Competence is having the necessary ability, knowledge, or skill to do something successfully. So why is training so important? To understand why something is important, we need to understand what its purpose is. The purpose of training is to ensure you and your employees are not injured or made ill by the work you do. It helps to develop a positive health and safety culture, where safe and healthy working becomes second nature to everyone. Find out how you can manage health and safety better, meet your legal duty, and protect the health and safety of your employees. Statistics show that about 20% of all injuries to workers occur within their first 30 days on the job. This fact highlights the importance of orientation. Newly hired workers may be young or old, male or female, experienced or inexperienced. The worker may be new to the site, new to the type of work, or new to the company. The training required to ensure that employees are conversant with the hazards and precautions necessary to ensure health and safety in the workplace must be explained. Risks, precautions required for safe work, equipment for safe work procedures, duty to report and monitoring of the quality of health and safety programs must be explained. The legal requirements in respect of training are explained for a specific workplace. The duties of employees to comply with health and safety requirements and reporting health and safety risks or threats must also be explained, and a process must be proposed to ensure compliance.